Okay, we are going to get started. Our speaker tonight is Glenn Roper. He is a senior lawyer. Is that how you say it, senior lawyer? He's a senior lawyer at the Pacific Legal Foundation, and he is the sharpest dressed man in the room. So please give it up for Glenn Roper.
All right, great. Well, thank you for inviting me to come and be with you today. I should have known with a group of libertarians, ties would have been optional, but I figure this way I at least look like a lawyer. So hopefully you'll think about that. I think the online description said I was going to talk about lessons in litigation. Well, I don't know how many lessons we're going to get. I'm more going to tell some stories, stories about some of our cases that we're working on. And let me start by asking you to imagine something terrible. I want you to imagine that you have a child who's been diagnosed with cancer. Now, there's a doctor who can treat this cancer, but the doctor lives in another state. So, of course, you'd be willing to make the sacrifice to travel there for appointments and treatments. But what if you just wanted to have a consultation or a conversation with a doctor? Well, it's easier to just pick up the phone or get on a video conference and talk to them. But then imagine that your state enacts a law forbidding you from having telehealth appointments with a doctor in another state. This is not just a hypothetical. That's the exact situation being faced by our client, June Abel. June is 13 years old, 13-year-old boy, and he is successfully surviving a rare and deadly form of brain cancer, thanks to the treatment provided by Shannon McDonald, his doctor, who is a renowned radiation oncologist at Massachusetts General Hospital. The problem is June does not live in Massachusetts. He lives in New Jersey. And New Jersey has a law forbidding doctors and patients from having telehealth visits if the doctor is not licensed in New Jersey. And Dr. McDonald is licensed in Massachusetts, not in New Jersey. So that means instead of picking up the phone and having a conversation or having a Zoom meeting or a FaceTime call or any of these kind of normal things that you would want to do in this day and age, June and his parents have to go get in the car, drive from New Jersey to Boston, have a meeting, turn around, and drive back home. This law supposedly is intended to help and protect patients like June. During COVID, of course, New Jersey suspended the law and allowed freely telehealth appointments, and unsurprisingly, there were no issues. But New Jersey is back to enforcing this law, and this is a law with teeth. It carries criminal penalties, and a doctor who has the temerity to have a telehealth appointment with someone in New Jersey, but is not licensed in New Jersey, can face up to 3 to 5 years in prison for this telehealth appointment. Matt?
How did New Jersey get jurisdiction over somebody who's has no connection with the state other than telehealth?
It would be the unauthorized, they consider it the unauthorized practice of medicine in New Jersey. Now, I guess that's a good question of could they extradite Dr. McDonald from Massachusetts into New Jersey, but they have this criminal law set up. And for a licensed specialist like Dr. McDonald, all the patients, all the children with cancer are not all going to live in Massachusetts. They're spread throughout the country. And particularly with these rare forms of cancer, of course you're going to have specialists who are not always in the same place as the patients. So Pacific Legal Foundation, we filed a lawsuit on behalf of the Abels and Dr. McDonald challenging what New Jersey is doing. And let me tell you just about a couple of our claims. One, we're bringing what is called a dormant commerce clause claim. And that's a constitutional doctrine saying that a state cannot unreasonably discriminate against out-of-state businesses, or in this case, out-of-state physicians. We're also bringing what I think is kind of a creative First Amendment claim, a free speech claim, saying that New Jersey or any state cannot criminalize a conversation between a doctor and patient depending on the content of what they're talking about. If they're talking about medical treatment versus having some other sort of conversation. Now, we just filed this case in December, so we don't have a ruling. I wish I could give you great news, but I'm hopeful that the courts will go our way and will allow licensed specialists like Dr. McDonald and their patients to have these conversations without these unreasonable restrictions. I think that case highlights some of what we do at Pacific Legal Foundation. And I should have asked, who's heard of PLF before? Anybody sort of familiar? Okay, good. That's a great group there. Well, for those who don't know, we're a public interest law firm that fights against the government, federal, state, local, when it's infringing on people's constitutional rights. I appreciate the shout out there. And I should say, we've been very successful. Last year, we notched our 17th United States Supreme Court victory. And in addition, we have many other victories at lower state and local courts, although we particularly love being in the Supreme Court, because there we can set precedent for the nation and will help protect constitutional rights nationwide. Unfortunately, we can't take every worthy case that comes to us. We focus our efforts in 3 different practice areas. We're probably best known for our property rights work, where we represent property owners against government intrusion. We also have what we call a separation of powers practice, where we fight to keep the different branches of government operating in their own spheres and then push back against the administrative state. I do most of my work in our 3rd practice area, which we call our equality and opportunity area. And in equality and opportunity, we work to establish some basic fundamental principles. Equality before the law, the right to earn a living in a lawful occupation, and then that people should be allowed to rise based on their abilities, their hard work, and their choices without undue government interference. So the New Jersey telehealth case that I talked about, that's an example of our opportunity work. Let me give you an example of an equality initiative that we're doing. So every state has a number of licensing boards that regulate different professions. You'll have the medical board that regulates physicians and the dental board and what have you. Now I want to set aside for a second whether all these boards are necessary. Whether professions like flower arranging and hairstyling and interior decorating require intense government oversight and regulation. Let's set that aside for a second, because at PLF we've identified another problem with these licensing boards. In about half of the states have this, where they have at least one licensing board that has requirements that at least one member of the board be of a particular race or gender. Let me give you an example. I just filed a lawsuit in Alabama a couple of weeks ago about challenging the state's real estate appraisers board. Now, a real estate appraiser, as you know, this is someone who comes and evaluates your property to decide whether it's worth what you say it is for getting insurance or a mortgage or what have you. The Real Estate Appraisers Board regulates that profession, disciplines them when necessary, licenses them, and whatnot. In Alabama, there's a statute that says the Real Estate Appraisers Board must have at least 2 racial minorities on it. That's written in the law. What that means is, if there's an opening on the board, like there is right now, and if there's fewer than 2 racial minorities on the board, right now there's only 1, any citizen who does not identify as a racial minority is excluded from the board because of their race. So we've brought a lawsuit. We have an anonymous client who would like to be on the Real Estate Appraisers Board, but because she is white, she cannot even be considered for this open position. We're challenging that as a violation of the Equal Protection Clause. And just, I know there are a couple of lawyers in the room, but just as a little bit of background on the equal protection, the way that works is the government is generally not able to consider race and treat people differently on the basis of race, unless it can pass what's called strict scrutiny. And that means to pass strict scrutiny, the government has to meet 2 prongs. First, they have to have a compelling interest in treating people differently on the basis of race. A very important reason to do it. And so far, the Supreme Court has only recognized 2 compelling interests. One is for the government to remedy its own racial discrimination. And then secondly, to avoid prison riots. So you can separate groups in prison on the basis of race to avoid gang wars and what have you. So unless Alabama can creatively come up with some other reason why the Real Estate Appraisers Board requires differential treatment on the basis of race, I think they'll have a hard time passing that prong. But even if they could show a compelling interest, The second prong requires it to be narrowly tailored. Any treatment of race has to be as limited as possible. It has to be done only after you've exhausted under other non-racial approaches. So I think Alabama's going to have a hard time satisfying these, but we'll see. We just filed that case a few weeks ago, and we'll see where that goes. This is not the only board. I show that as just one example. There are actually dozens of these boards, and like I said, in about half the states around the country where they have racial or gender requirements to serve on these public boards. And many of the people who serve on these boards are just citizens like you and me, who just volunteer their time to help it with licensing a particular occupation. So I mentioned Alabama. We filed similar cases in Tennessee and Louisiana, a couple others that we're working on that I won't say because we haven't filed them yet, and then also in Iowa. And in fact, a couple of weeks ago, we got a great court decision in Iowa where the court struck down Iowa's Judicial Nominating Commission. So this is the group of citizens who get together to decide who should be the state judges. And it had a requirement that you had men's seats and women's seats. So if there was an opening in one of the men's seats and you were a woman who wanted to be on this board, you couldn't even be considered because you were the wrong gender. So that's a great decision that we just got. I'm hopeful we'll get some other positive decisions in these cases. Speaking of Iowa, let me tell you about another opportunity case. I have a couple of clients in Des Moines, Emily and Caitlin. And Emily and Caitlin are both certified midwives. And they've come up with a business idea. They want to start a freestanding birth clinic where women can come and give birth in an environment that they help design in a comfortable situation, low-risk pregnancies only, and give birth there with a midwife. Well, in Iowa, you can give birth at home with or without a midwife. You can give birth in a hospital. But to set up a freestanding birth clinic, like Caitlin and Emily want to do, they first have to go through the gauntlet of what is called Certificate of Need. Anybody ever heard of Certificate of Need before? Good, a few people here. Fortunately, we don't do a lot of this in Colorado, but there are a lot of states back east and in the Midwest that have these Certificate of Need laws. And the way it works is this. If you want to set up a birth center, before you can even submit a business application or start buying the land, getting it all set up, you have to go to the State Department of Health and convince them that your business is needed. And if that sounds kind of arbitrary and subjective, it is. The way it works is you have to convince them that the demand exceeds the current supply. And to make matters worse, the existing businesses, in this case the hospitals, they can come in and protest your application. And believe it or not, surprisingly, they always say that they can handle the current need, and there isn't a need for additional competitors. And so essentially what this law amounts to is a competitor's veto, where the existing businesses can come in, and instead of the expecting mothers, the existing hospitals get to decide what options you have for where to give birth. We've brought a lawsuit on behalf of Caitlin and Emily challenging this law, the Certificate of Need process, and we're basically trying to assert two kinds of rights. First, the right of Caitlin and Emily to be able to start a business and try. Maybe they won't be successful, but they should at least be given that opportunity. But not only their rights, but also the rights of expecting mothers who to give birth in the place and manner of their choosing. We think that's an unenumerated constitutional right that the court should protect. Since we still have some time, let me give you another example, sort of related to that Iowa case. This has to do with Parker Noland. He's in his mid-20s right now. After Parker was honorably discharged from the Army, he went back to his hometown in Montana, and he started working construction. While he was there doing that job, he came up with a business idea. He saw that a lot of these construction sites, they would have debris that would pile up, and sometimes these big construction dumpsters wouldn't get emptied, and they'd start to overflow. And so he went out and he bought a truck and a trailer and a dumpster, and he would go around and offer to haul away the construction debris. Well, once he started doing that, he got a cease and desist letter from the State Public Service Commission because he was hauling garbage without a license. That's not the worst of it. So he thought, okay, I'll go in and submit an application. Well, it turns out that for hauling garbage in Montana, there is also a certificate of need process. They call it a certificate of public convenience and necessity, where you need to go and convince the Public Service Commission, this 5-member commission, that there is a need for an additional garbage hauler. And just like in Iowa, the existing garbage companies can come in and protest your application. And I don't know how much you know about the history of the sanitation industry, but they are very aggressive, and they hire very bulldog lawyers who they come in, they overwhelm you with discovery requests and protests, and really try to exclude people from competition, from competing with them. And that's exactly what happened to Parker. After he'd spent several $1,000s on an attorney trying to navigate this process, he just withdrew his application because it was too hard to try to go through this gauntlet. So we're representing Parker, challenging this certificate of public convenience and necessity process in Montana. We're shortly going to be before the Montana Supreme Court. The interesting thing about Montana is the Montana state constitution. So a lot of what we do is federal constitutional rights, equal protection, due process, those, the First Amendment. The Montana state constitution has a provision giving you the right to pursue life's basic necessities. And the way that the courts have interpreted that, it includes the right to seek employment in your preferred industry. And so we are using that as a basis of our claim on behalf of Parker that this PCN process is unreasonably setting up an obstacle to him being able to pursue this right. So we'll shortly be before the Montana Supreme Court, and hopefully we'll get a positive decision there on behalf of Parker. Finally, let me tell you about another area of our equality work. And yeah, go ahead, Matt.
Question, how many other states have an analog to that constitutional provision? That's very interesting.
Yeah, that's something I've actually done a study on recently. Montana's is unique. So the question was, how many states have an analog to Montana's? Montana's language is unique, as it should be. The states should be able to define constitutional rights in the way that their citizens see fit. So there are no other states that have that exact language. There are a handful of states, fewer than 10, I think, that have something along those lines. The one I'm thinking of right now is in North Carolina. They have a provision saying you're entitled to the fruits of your labor. And I think Oklahoma has something similar. So there are a few states that have this. And given how reluctant the United States Supreme Court has been to protect federal rights to earn a living and to start a business, this is an area that I think will be fruitful in the coming years, is to rely on state constitutional provisions like Montana's or North Carolina's to help protect economic liberties. I think the current Supreme Court is great on a lot of things. First Amendment, equality, they're pretty terrible and have been for at least a century on protecting economic liberties. Someday the slaughterhouse cases will be overruled, but for now we're stuck with that. So let me tell you about an area of our equality work, and this is in K through 12 education. Many of you are probably familiar with the Supreme Court decision last year in the Harvard case, where they struck down Harvard's discriminatory admissions policy. Unfortunately, a lot of that same thing is happening in competitive high school and middle schools around the country, where school boards are applying discriminatory application, have discriminatory application processes. And let me tell you about one of the most ridiculous examples. And this is in Hartford, Connecticut. So not Harvard, this is Hartford. And Hartford, Connecticut has some world-class magnet middle schools. They've really put a lot of resources into these, hired the best teachers, set up, there's STEM, there's performing arts, really great middle schools that help prepare students for high school and college and successful careers. And they really are great schools. LaShawn Robinson, our client, was very concerned about her son Jared, how he was doing in school. He was being terribly bullied. It was leading to depression. His grades were going down the tubes. So she decided to apply to get him into one of these magnet middle schools, a better environment, great teaching and education resources. Her application was denied. And the reason it was denied is because LaShawn and Jared are black. Now, let me explain how that happened. Hartford, in pursuit of diversity, decided that at these magnet schools, there had to be at least 25% white students. You couldn't have more than 75% black and Hispanic students. Apparently, Hartford thought that black and Hispanic students need the educational benefits that come from associating with white students in order to be successful. So they enacted this 25%, 75% law. Well, what happened is when you had too few white applicants, and that happened because you don't have a lot of white families living in downtown Hartford. They had moved to the suburbs. When you had too few white applicants, to keep this 25-75% ratio in place, they had to turn away black and Hispanic students even when they had open seats at the schools. So they're sitting there, this racial quota was so important to them that they would rather keep people out of the schools than to give up this diversity quota that they'd put in place. Well, we represented LaShawn and Jared in suing to challenge this. After fighting us vigorously for 7 years, the state of Connecticut finally caved and stepped in and eliminated the racial quota so that students like Jared Robinson can attend these top-notch schools. Yeah, unfortunately, Jared, he ended up going to, he ended up dropping out of high school and fortunately went to a trade school. Now seems to be doing very well personally, but yeah, he missed that window. Fortunately, LaShawn has other younger children who were able to apply to these schools. That does raise an important point, which is often, and I guess this is a lesson from litigation, these fights take years. It is very challenging to fight against the government. They do not give in on many things. I feel like often we fight for months or years with the government about, can we even bring this case in the first place? One of our Supreme Court victories last year, Sackett versus the Environmental Protective Agency, this case has been going on for 15 years, where the Sacketts, who own a piece of property in Idaho, wanted to build a house. The EPA came in and said, there are wetlands on your property. Wetlands that connect to these other wetlands. And then if you go through the ditch and under this culvert and then 300 yards down the street, then there's a navigable water. So we have jurisdiction and can keep you from building your house. Well, we filed a lawsuit on behalf of the Sacketts, lost at the district court, lost at the Ninth Circuit, went up to the Supreme Court. The Supreme Court said, yes, you can bring your case. That's what the first fight was about. Went back down to the district court, lost at the district court, lost at the Ninth Circuit, and then last year, finally, the Supreme Court ruled in our favor and said, this is an unreasonable interpretation of the extent of the authority of the EPA. Unfortunately, often in our cases, the individual who is harmed doesn't always get the benefit of a positive decision. But they really are the heroes of what we do. Our clients who, it takes a lot of guts, frankly, a lot of fortitude and determination to stand up and say, I am taking a stand against this infringement of my rights. So many of us, so many of our citizens are just go along with what the government does, and it's understandable. It's not worth the hassle. It's not worth the bother. I think, fortunately, at Pacific Legal Foundation, we can provide the additional incentive of we're not charging you attorney fees, so you don't have to pay tens or hundreds of thousands of dollars on top of this. But it's still you can get some detrimental news coverage. You have to, sometimes you get your deposition taken from aggressive government lawyers, and it can be a years-long fight. But they really are the heroes of what we do. Back to the K through 12 schools. I think the Connecticut case is a great success story. Unfortunately, there are still many school districts that continue to apply discriminatory policies. Currently, the target of these policies tends to be Asian Americans. They have been, for whatever reason, culturally, what have you, they've been particularly successful in getting admission to these schools, which often are based on standardized tests. And there are school districts who think that's a problem and are concerned that the schools, these competitive schools, will become too Asian. Now, you might think these are scare quotes. That is a quote from an internal text message between school board members that we discovered in one of our cases, where that was their concern. The schools were becoming too Asian, and so they needed to change the admissions policies in order to reduce the number of Asian American students who were getting into these schools. So we continue to fight. We've got cases in New York City, in Boston, in Maryland that are raising these challenges to discriminatory K through 12 admissions policies. And it is my hope that soon the Supreme Court will grant one of these cases and will do for K to 12 education what it did for university education with the Harvard decision of last year. After hearing about some of these cases, you may be wondering, what can I do to help? At least I hope that's what you're thinking after hearing what we talk about. And I'll mention just two things. First, we need to hear about the infringement of rights. We can't stand up and defend somebody if we don't know that there's a problem. I've got a whole stack of cards, business cards. If you want to get my information, I'd love to hear about things that you're aware of, where individuals' rights are being infringed on and where we may be able to help out. Like I said, we can't help in every worthy case, and there are many cases where we just have to say that that's a horrible situation, but not something that we can help with right now. We're looking for those cases where we can have a broad impact, where we can set a precedent, Supreme Court type cases where we can set broad precedents that will help the country. But making us aware of these issues is something that's very important. And then the second thing, and you being here tonight, I think helps with this, and that's become educated about these issues. Learn about the things that are going on around you. Be aware of the legislation. I'm happy to hear about some of the events that are going on. I think Colorado is a worthwhile litigation target, and one where I'd love to bring some cases here. But you can learn more about these cases that I've talked about. I've talked about just a handful. We've got over 100 cases going at any given time, including in our property rights and separation of powers cases. Learn more about these cases and the issues that we think are important. I think our media team does a good job of producing videos and other content that you can learn about. PacificLegal.org is our website. I encourage you to check that out. And with that, thank you for letting me come and speak to you, and I'm happy to answer questions.
Thanks for being here. I ran into a situation during COVID where I was not allowed on public transportation. I had Lysol put in my face, and I was kicked off the bus, and I was rejected by the bus drivers, and I was rejected, and I had the Denver City Police kicked me off of the bus. Is there something that I could do about that? I have several instances of that.
Yeah. I don't know what the statute of limitations would be, depending on when it happened. Sometimes you've got to bring a claim within a certain number of years of when it happened. Those cases are egregious. They can be pretty hard to prove. And unfortunately, this is another lesson from litigation. Judges tend to favor the government. There's really no other way to say it. The government that employs them, and there are all these doctrines that have sprung up that makes it more difficult to bring claims against the government. Police specifically, you have what's called qualified immunity, where unless that exact thing happened to somebody else and a court ruled on it and said that violates the Constitution, then basically they say, well, you may have a good claim, but it's not something we can do anything about. The better documentation you have as to what happened, if you catch things on camera, that's on video camera, that's always good. So, without offering legal advice because I am not your lawyer. The best I can say is possibly you could have a claim there, but it could also be a very difficult one to try to prove.
I'm curious if there are some states that are worse than other states. I have my opinion what they might be, but I'd like to hear your opinion, please.
Yeah, my guess is that you could guess the worst states pretty easily. California is a terrible one, and New York is a very terrible one. Maryland is a very, we see a lot of egregious things happening there. But no state is immune. We have cases, I don't know if I mentioned this, we have cases in nearly every one of the 50 states right now on various issues. We were talking the other day, after California, we have a number of cases in Montana right now, unusually, which I usually don't think of Montana. Montana, I think, is one of the more live and let live kind of states generally. I would hope, but that is not playing out. Trying to think of those are the ones that come to mind as particularly egregious ones. Massachusetts as well. Yeah.
I have a question about, so you mentioned having to file in all these different states, and I'm sure that requires, having lawyers that are member of the bar in all of these states. Have you challenged, being a member of the bar, that's a licensing board type of thing.
Yeah.
Have you challenged that also at the federal level?
One of our first Supreme Court victories had to do with that kind of issue with mandatory bar membership. That's not something that we're doing right now. I am aware of a couple other organizations that are challenging the mandatory bar membership. It turns out to usually not be much of an obstacle for what I do. Most of what I do is in federal court, and federal courts are usually pretty willing to let you come in and what they call pro hoc vice, which is like temporary. I want to come in and temporarily practice in your court for this particular case. You pay a fee, and they say, "Great, we'll let you in." But that is a live issue, and it is being litigated not by PLF right now.
Thank you very much. Do you all ever go against the IRS?
I can't think of an instance where we've had a case directly against the IRS.
Do you consider the IRS and the U.S. taxation system constitutional?
The 16th Amendment would say that the income tax is constitutional. I think there may be aspects of the IRS that violate the separation of powers. I will say this isn't the IRS, it's a different federal agency. Pat asked about what states are the worst. I think when you get to federal agencies, the SEC is actually one of the worst in violating constitutional rights. I can't think of a case we've brought against the IRS. If you've got a great idea for a winning issue, let me know.
Okay, so furthermore, do you consider the IRS a corporation? Do you consider the U.S. government a corporation?
A corporation?
Yeah.
That feels like it may be a loaded question. I would say not for most purposes. It would really, I'm going to give the lawyer answer. It depends. It depends on the context that you're talking about. But I would think generally not.
As a layperson, it just always blows my mind that we're legally allowed, or the state is rather, legally allowed to violate our constitutional, legally protected, or should I do air quotes, rights? Broad strokes, how did that come to be?
James Madison, in talking about the separation of powers, said it is so important so that ambition would counteract ambition. And if you look at, he said something like, if men were angels, no government would be necessary. But the reason that we have the government set up in the way it is originally set up in the Constitution is to provide checks and balances among the different branches so that they will, the ambition of the executive branch will be counteracted by the legislative branch and the judicial branch. So one reason why a lot of rights end up getting infringed is because those boundaries start to blur and aren't being rigorously enforced by the different branches and by the courts. If you think about it, who is there to protect your rights? Well, it should be the government itself, but if they're not policing themselves, what do you do? And that's one reason why I think it's important, the kind of work that we do at PLF and other organizations, because somebody needs to put a check on government power and protect people's rights. I think often the courts are willing to provide that protection eventually, but they can't just go out and make laws. The case has to be brought to them. For the Supreme Court to rule on something, there has to be a case that goes through the procedural gauntlet to get in front of them and present a question in a way that they can answer. Most of our rights should be protected by the legislature passing laws that protect in a way that protect our rights and preserve our rights. When that's not happening, the courts are there, but there's got to be somebody willing to stand up and take it there.
Yeah, kind of riffing on a couple of these themes, and I think the gentleman back here made an excellent point. And Justice Gorsuch famously said in a concurrence that what happened during COVID was the most massive violation of civil rights that we've seen since the Civil War. The problem is that the checks and balances have not worked. Legislatures have ceded their authority with emergency powers, and they actually pass laws to give up their authority. And many states have gone so far overboard on that governors essentially act as tyrants and kings without any check. Public health agencies act as tyrants and kings with no check to their authority. This will continue, I think, unless these people are held accountable. What do you think of using Section 1983 to go after and not just hold the government as an aggregate accountable, but hold individual elected officials personally responsible for their violations of civil rights and wreck them financially and take away their ability to ever hold office in the future as they try to do to the citizens?
Yeah. I would say it's hard because of some of these doctrines that I've talked about. You have this doctrine of sovereign immunity, which is, we inherited from England, where it's like the king can do no wrong. That was the doctrine in medieval England. That has come into American jurisprudence, where you have this doctrine saying the state can do no wrong. You can't sue the state unless it gives you permission to. And then when you get to individual officers, you have the doctrine of qualified immunity, which protects them from individual liability, except in the most egregious cases. Now, I think there are avenues to do that. I think the Supreme Court hasn't shown a lot of appetite to overturn qualified immunity, but I think there's a possibility for that. I actually have a qualified immunity case in Massachusetts right now, where the Department of Children and Families came bursting into this home at 1 o'clock in the morning and took the kids away based on a months-old injury that showed up in an X-ray. But it's hard. These are difficult fights, and personal accountability, sometimes dollars speak louder than anything else. So in the right situation, that is something that we'll seek to do, is to hold people individually accountable to help send that message. But it's hard. There are a lot of bricks stacked against you when you're trying to go down that route.
What precedent would you like to see overturned during your career, and why is it Wickard v. Filburn?
There was a Liberty organization that did a March Madness type bracket as to the worst Supreme Court decisions, and I think Wickard won. For those who don't know, Wickard versus Filburn, this is a dramatic expansion of the commerce power, where the Supreme Court held that an individual growing crops at his house for his own use and use of his animals was engaged in interstate commerce, and so Congress could regulate it. I think that's a bad one. To me, the slaughterhouse cases are a worse one, because that's where the 14th Amendment has this great language protecting our privileges and immunities as citizens. In the slaughterhouse cases, the Supreme Court basically read that out of the amendment and said, privileges and immunities, that really doesn't mean anything other than, like, on the high seas, you're protected from certain against certain federal infringements. When the provision was put in there to protect individual rights, some of the very things that we're talking about tonight. So Wickard v. Filburn is a terrible one. For me, the slaughterhouse cases I'd rather see that one go away. Although I actually have a colleague who's working on a potential Wickard case right now. So.
I'm sure your resources are limited. When you choose a case, what criteria do you use?
Yeah, great question. Every case is going to be evaluated differently, but some of the things that we look for: a great story, something that we can go to the press with and tell. Not just we're not just talking to lawyers and judges and legislatures. We're also talking to everyday people. So most of our clients are individuals or small businesses or associations that simply wouldn't have the resources to protect their rights without it. So someone who can tell a great story where, I think the best cases are one where the everyday man or woman on the street would be outraged in hearing what has happened. Hopefully you felt a little bit of that in some of the cases I talked about tonight. And then cases that are going to make a difference beyond just the specific circumstances of that case. A case where we can set an important precedent, where we can overturn the Wickard versus Filburns of the world. Now, not every case can even hope to achieve that. But in every case that we take, we do have a goal, a broad goal of establishing some constitutional doctrine. So, for example, in the Iowa midwife case, I would love to have a court rule that pregnant mothers have a right to determine the place and manner of giving birth. That is one of the fundamental rights that they have as citizens. It's not listed in the Constitution. You can't say go to Article 3, Clause 2, and it's written there. But the Ninth Amendment says that just because we list things in the Bill of Rights, that doesn't mean there aren't other rights that aren't listed here. And the 10th Amendment says those rights are guaranteed to the states and to the people. And so there are many rights that I think should be protected, and so we look for that. Do we have an opportunity to establish an important precedent, to expand the way that rights are being viewed, to overturn a bad precedent? And so a great story, a client who's willing to be in it for the long haul, and where we can establish an important precedent. Those are some of the things that we look for.
We're going to do 3 more.
This may be a rather naive question on my part, but what happens to a case in which the person that brought it forth, maybe to PLF, passes away? Does the case continue, or what happens in those circumstances?
Yeah, funny enough, that's actually happened at PLF. Usually the case goes away. In this particular case, this was an individual, Joe Robinson, who was criminally prosecuted under the Clean Water Act. That's unusual for them to impose criminal liability, but he was digging out a piece of water on his land, or an area on his land that filled with water. He was criminally prosecuted for violating the Clean Water Act, and we ended up taking that all the way to the U.S. Supreme Court. He unfortunately passed away while his case was pending. And so in that circumstance, the Supreme Court reversed his conviction because it hadn't become final through the appeals. So at least his widow could appreciate that his conviction was overturned. But then the case went away because unless you have this legal fiction of your estate that continues after you die, unless the estate can somehow get relief, then usually if the client passes away, then the case goes away. Government is always there.
So how many cases are you options are you requested to look into in a year versus how many do you take? How many cases?
It really depends. I will say during COVID, the number of public requests that we got on our website skyrocketed. We were getting hundreds of requests a month, and we had maybe 5 or 6 COVID-related cases. And that, I do want to comment on another thing that Matt Arnold said about emergency powers, because that was one of the cases that we brought, is challenging the governor of Kentucky's going outside his authority of what he did. So we probably, I don't know how many public requests we get, hundreds, thousands a year. At any given time, we probably have, I think I heard right now we've got 140 active cases right now. And some of those have been going for years. So we really have to be selective in the cases that we take. Unfortunately, I wish we could give representation to everyone whose rights are being affected, and that's why we try to pick those cases that are going to have a domino effect and a larger impact. And in part, also to Matt's question, we also have a public policy arm, a group that will go to legislatures and propose legislation. So following COVID, we actually drafted an emergency powers bill and proposed it to legislatures as ways that they could rein in the authority of governors that really went rogue during COVID. And there were at least a few legislatures that hadn't realized how broad of authority they had granted, and took our legislation and enacted it to provide some reasonable limits on that.
2 questions. First, how are you guys funded? And then 2, can you talk about enforcement? So if you guys win a case at the Supreme Court, how often does that have like national implications, and how often do people actually follow them, and what happens if they don't follow them?
Yeah, we are entirely donor funded. We've got generous donors who believe in our mission all around the country, and who provide support, which I couldn't do what I do without their support. So I guess they're also heroes in what we do. Second question, what had to do with enforcement? I would say 2 things. When a court makes a specific ruling, the government is usually pretty good at abiding by it, until the point when they can change something about what they're doing in a way that doesn't directly contradict. So, because of sanctions that they can face if they just try to be kind of openly defiant, when a court issues something, they will usually, go along with it. Particularly when it's the U.S. Supreme Court, like there's nowhere to go at that point. You comply, but they will then follow up. It's a little bit of whack-a-mole sometimes, right? Like take down this particular thing they're doing, and so they pop up and do something else. And that was particularly bad during COVID, when we'd bring a case, and then 2 weeks later they would change what they're doing and argue that our case was moot because we were challenging something they weren't even doing anymore. And trying to get cases moving fast enough to actually get the issue addressed was a problem. So I would say, in the best circumstances, like in the Iowa case, the Judicial Nominating Commission, where the judge ruled that you can't have like men's seats and women's seats, you can't exclude people on that basis. After the court ruled, we then went to the Iowa legislature and said, hey, here's what the court ruled, here's our proposed change to the law, and that is quickly moving through. I'm fairly confident that they're going to improve and enact that. Sometimes to solidify a victory, we've got to go through legislative or other means to actually get it put in place. But usually they won't be openly defiant. They'll just try to find a workaround.
That's our talk. Give it up for Glenn Roper.
All right. Thank you.
Thanks, everyone, for coming out. We will be back in 2 weeks. Ian Escalante from Rocky Mountain Gun Owners will be here, so please come out for that. Drive safe, have a good night, and keep fighting the state.